Hi, Attorney Jeff Morrell here. This is the third in my series of short informative videos entitled Basic Rights of the Criminally Accused. If you're a criminal defendant in a formal case in this country, you have the right to force the prosecution to present evidence of your guilt beyond a reasonable doubt at a trial. Your attorney can and will make recommendations as to whether or not it's prudent under all the circumstances to take a case to a trial, but the decision is ultimately yours as the defendant in the case. In Wisconsin, the prosecution has a voice in whether to allow you to waive a trial by jury. That usually comes into play when a plea bargain is reached, when you, through your attorney, agree to enter a guilty plea in exchange for the prosecution's promise to make a specific recommendation at sentencing. And in the event that does happen, the state needs to also agree to waive a jury trial. They can actually say no, but since starting my practice in 1995, I've never seen a prosecutor not waive a jury trial to accommodate a plea negotiation. The decision to take a case to trial is a multi-pronged approach. First off, a defendant has to decide whether or not he or she wants to take advantage of any offers by the prosecution to settle the case short of a trial. As I said earlier, what usually happens is the prosecution in a plea bargain will make an offer to specifically recommend something at the sentencing. Say the defendant is accused of felony robbery and there was some violence involved, which normally might warrant some jail time. Well, let's say the prosecutor offers to recommend a few years probation. The defendant might decide that's more acceptable than rolling the dice and going to trial and possibly losing, and then seriously looking at some prison time. In the event the client does not wish to accept any sort of plea offer, then the decision is twofold when it comes to taking a case to trial. First, the defendant has to decide whether or not the defendant wants either a jury trial, that is, the case is put before 12 people from the defendant's immediate community, or whether or not the defendant would like to take the case to what we call a bench trial. And that's when the jury is waived. Again, the prosecution has to weigh in and acquiesce to that, and the trial is then solely before the judge. Instead of having a jury of 12 peers from the community act as triers of fact, the judge then sits in that place. There is one juror, essentially, and that's the judge. The judge is the trier of fact as well as the trier of law. Over the years, I've won many jury trials. Of course, I've lost my fair share too. My approach to criminal cases is simple. As long as it's not unethical or illegal, I do what the client wants. If the client decides that he or she wants to take a case to trial, either to a jury or a judge alone, and I think it's imprudent or not in that client's best interest under all the circumstances, I make my opinion crystal clear, but I do not push the client to do what the client does not want to do. Conversely, if the client is too afraid to take a case to trial and wants to negotiate and does not want to roll the dice on a jury's verdict, and I think it's probably in their best interest to take the case to a trial, I will not push the client to try the case. I will abide by the client's wishes. If you're in serious legal trouble and you need help, call me or email me for a free consultation. Doesn't cost you anything but a little time. I'm Attorney Jeff Morrell. I'm in Milwaukee, Wisconsin. I help people throughout southeast Wisconsin and in certain cases other parts of the state. The number is area code 414-224-0668.